Walton v. Lexon Insurance Company, Pacific Construction, Soleim, or Max Soleim. Who do I have present on this matter?
Peter Walton here, Your Honor.
Okay.
Good afternoon, Your Honor. Daniel Mooney on behalf of the defendants.
Jesse Conway as well, Your Honor.
Okay.
On behalf of the defendants.
All right. Okay. So I guess let me hear from plaintiffs if you are still planning to proceed on your request for default.
Yes, Your Honor.
Okay. Did you receive the defendant's answers and affirmative defenses?
Yes, I did.
Okay. So then go ahead with your reasoning for requesting default.
Okay, Your Honor, defendants claim they lack proper notice under CR 55A3. Their own Exhibit 3 directly refutes that. It contains the June 20th notice I sent, which included the motion for default, supporting declaration, proposed order, and civil calendar docket notice, providing a 25 days notice, far exceeding the 5 days required. Notice was therefore timely and adequate. Second, CR 55A1 is disjunctive. A party may be defaulted for failing to appear, plead, or otherwise defend. Any one failure suffices. In their response, defendants read the or as and, but the plain language of the rule controls. Third, the appearance and representation issues are straightforward. Attorney Jesse Conway formally appeared for all defendants, including Lexon, on April 13th. Under CR 71, he remained counsel of record because he never properly withdrew. No notice of intent to withdraw or notice of withdrawal and substitution was ever filed. Neither Wilson Elsner nor Mr. Volovovik ever filed a notice of appearance under CR 70.1 for any defendant or for Lexon specifically. Under CR 70.1, an attorney becomes counsel of record only by filing and serving a formal notice of appearance. CR 70.1 and CR 71 together create an exclusive framework for representation and signing pleadings. These rules operate in harmony with CR 11 and RCW 2.44, which require pleadings to be signed by the attorney who is actually counsel of record. As a result, all answers are invalid. None bear Mr. Conway's signature. The Volovovik answer was never filed, and even the response to this motion lacks Mr. Conway's signature, despite being the only document for which he gave email permission. Additionally, all defendants are in default for the same core reason. None filed a timely or valid answer to the First Amendment complaint. Service was complete on June 1st, making answers due June 11th. Under Washington law, a substantially amended complaint requires a new responsive pleading. The amended complaint added detailed factual allegations, expanded claims, updated exhibits, dismissed certain claims, requested additional relief, and incorporated new facts about defendants' unlawful conduct. Mr. Conway's original answer does not address these changes. Every subsequent filing is procedurally void because they were signed by unauthorized counsel, lacked the required signature of counsel of record, and contained contradictory, unreviewed denials. Defendants' request for CR 11 sanctions against me is without merit. It rests entirely on their incorrect interpretation of CR 55A3 and the mistaken claim that valid answers were timely filed. I brought this motion after defendants failed to answer timely, provided more than required notice, followed the rules, and acted in good faith. Filing a motion expressly authorized by CR 55 is not sanctionable. I respectfully ask the court to deny their sanctions request. In conclusion, appearance is undisputed. All defendants appeared through Mr. Conway. The only relevance of appearance was proper CR 55 notice, which was fully satisfied. Because no valid answer to the First amended complaint exists, all defendants remain in default. I respectfully request that the court strike the invalid answers, enter default against all defendants, and set this matter for a separate hearing on damages. Due to the logistics of obtaining estimates and bids, I will need approximately 2 months to complete the damages evaluation. Thank you, Your Honor.
What are you reading from, Mr. Walton?
A thing that I prepared for this hearing.
Okay. How did you prepare it?
By putting everything together.
And how did you put everything together?
By reading all the documents, all the filings. I spent hours putting together dates. It took me probably about 3 hours to get this prepared. make
Yeah,
sure it
what-
was edited so it wasn't too long.
What sources did you use?
The documents and research, RCW 2.44, the court rules.
What
I've
type
been
of,
involved in numerous lawsuits, so I'm familiar with how to research and look up case law and things like that.
no, and here's why I'm asking specifically. I'll get to the heart
Okay,
of the
go ahead.
question. In your research, did you come across case law specifically on courts contemplating and preferring that cases be heard on the merits?
Yes, I'm familiar with that, Your Honor. But in this situation, we have if you read through all the documents, there's a Lewis County case that was ordered transferred. That's still in the works right now. But if you read through everything, this is kind of a unique case. Excuse me. Right now, we have answers that were filed to the First Amendment complaint, which was substantially, different than the original. And there's contradictions. It doesn't look like anybody properly reviewed it. There's like discrepancies between this answer, what was filed in Lewis County as a verified amended complaint. There's just so many different things. I think this,
But then
I
you've
understand the court. Go ahead.
But then you've also received the July 13th answer to the first amended complaint, which is prior to today's hearing, right?
The July 13th. No, I didn't receive a July 13th answer. I received one on June 23rd or
I
23rd.
Apologize. July 13th is the date it's scanned into our system, but it's the June 25th answer. You
Yes.
have received that, correct?
Yes. And my argument
And-
is what I just laid out, that it's invalid.
So wouldn't that go though to the merits of the case? If you're saying it contradicts other things, doesn't that more go to the merits versus me granting you a default saying they haven't answered? Because they have answered, and whether you agree with their answer or not is for this court to decide. Doesn't that seem to make more sense?
Well, I understand that, but as far as the rules go, it wasn't signed by the attorney of record, so it's invalid. I have two different answers that were served. One was never filed. I assume it might have been rejected. And then, so it's not like I obviously dispute their answer. There's misstatements of, a bunch of contradictions. But my position right now is that they are in default. They didn't file a valid answer. According to CR 11, every pleading must be signed by the attorney of record, and that simply didn't happen. Lawyers,
Right. Thank
that's
you,
my
Mr.
position.
Yep, thank you, Mr. Walton. I appreciate it.
You're
All
welcome.
right, for defense, I don't know who wants to take the lead.
I will start, and then perhaps Mr. Conway can address the second answer. I mean, we're here, Your Honor, because for no good reason, right? As the court is astutely aware, the answer has been filed. It was filed on June 25th. Every other argument Mr. Walton has made to this court, presented to this court, violates CR 11, and reflects a profound misunderstanding of the rules. It is parties who appear in litigation, not lawyers. Parties appear, lawyers do it on behalf of parties. Once the party has appeared, they have to be given the notice. The fact that Mr. Volovovik or my office subsequently associated on behalf of these clients does not change the validity of the answers that have been filed. There is absolutely no legitimate reason we should be here. How Mr. Rosenberg and how those first cases that on the docket this afternoon, that's how this situation is supposed to be handled. The fact that Mr. Walton has ChatGPT or may have ChatGPT and has read it and doesn't understand the rules isn't a defense here. There is no good reason why my client should have had to pay to be at this hearing. The answer was filed by an attorney of record back the day after he filed his motion. Had he sent an email and provided the notice before filing the motion saying, hey, if you don't give me your answer, I'm going to file a motion for default, we would have said, oh, geez, here's the answer. So instead he files the motion. We say, hey, here's your answer. Please strike your motion. And then we get these meritless arguments that reflect a profound misunderstanding of the rules. The court is well aware he is supposed to be held to the same standard as an attorney. The fact that he is pro se doesn't excuse this. I gave him plenty of warning that I would be asking for sanctions if he didn't strike this hearing. And he has refused. He should be sanctioned. This type of behavior should not be tolerated. None of us need to be here right now.
Mr. Conway, go ahead.
Yes, Your Honor, nothing too much to add. We have, and I know that this is probably the first the court has heard on this, but there has been a long, tiring history of AI, appeared to be AI generated motions and responses and challenges to everything. And most of what we do is met with, threats of CR11 sanctions. And we did get the answer in, and Mr. Mooney did, and I think he included the emails, but he did remind Mr. Walton several times of the rules here and how much it would cost us to come in and sit on this docket. I've now been here almost an hour. So that's where we're up against. The answers in. Can't default to party if they have any answers. So we're just looking at what do we do from here so we don't have to keep appearing for these things when we really shouldn't be here. So I'll concur with everything else Mr. Mooney presented.
Mr. Walton, anything briefly further that you want me to know?
Yes, Your Honor. As far as their arguments, I mean, the rules are the rules. I don't know why they keep misstating the rules. I'm not required to serve them notice before filing a motion. I mean, the plain language says 5 days before the hearing, so I don't know where that's even coming from. But first, CR55A3 notice was fully satisfied. Their own Exhibit 3 shows that my June 20 email with the motion, blah, 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 was received, given 25 days notice. Second, appearance is undisputed. Mr. Conway appeared for all defendants on April 13th and never withdrew. No other attorney filed a notice of appearance. A notice of association is not the same as a notice of appearance. It's right there in the rules. It's pretty basic. Third, none of the answers are valid under CR11 or RCW 2.44 because none bear Mr. Conway's signature. Finally, no valid answer to the First Amendment complaint was filed by the June 11th deadline. These arguments about that I'm required because other attorneys withdrew their motion and all this nonsense about frivolous misunderstanding the rules. I know how to read, Your Honor. Apparently, I don't know why they are. It seems to be purposely misleading, trying to mislead the court.
Okay. So
regardless of today's arguments, the procedural posture is unchanged. Notice was proper. Appearances are clear. Signatures are missing, and no valid answer exists. Default is appropriate. And I find it very insulting, this AI stuff. He's accusing me that I didn't write this stuff when I did. If you look through my whole history with this court, I mean, before AI was even a thing, you can see that I'm consistent. I read the rules, I read the law, and except for right now being accused of what they're accusing me of, it's kind of frustrating. But with that, I'll leave it to the court. Thank you.
Yeah, so the reason that I called this case at the time that I did, Mr. Walton, was that I was hopeful that you would see the other cases that were on for default that frankly were in very similar position, and actually probably a worse off position than yours because there was an answer filed and then by one attorney and then there's an answer filed by another after notices of association of counsel. And case law is very clear that if you show up to this hearing, you're requesting default and an answer has been filed, the court's going to deny it. So I am denying your motion for default. It is not grounded in the facts of this case. There are proper answers that have been filed to the amended complaint. So I'm having a hard time following your logic as to trying to parse out who signed what when. By all accounts, the attorneys, when they filed their answers, have indicated who their clients are. So there's simply no grounds for default. Again, the reason I called this case when I did was I was hopeful that when I came to you, Mr. Walton, you would acknowledge to the court that answers have been filed and you were striking this request. Because that hasn't happened, I am required to deny your request. And I am going to grant CR11 sanctions for the attorneys having to be here and argue against default.
Okay.
I only have, I don't know if it was Mr. Mooney or Mr. Conway, I only have the proposed order that was scanned in, so if you can get a clean copy to the court without the word proposed, I will get that signed and filed, and then the parties can do with that what they may.
Thank you, Your Honor. To you shortly.
All right, thank you.
All right,
Thank
thank you,
you
Your
all.
Honor.
Yep, thank you.